Can my employer track me with GPS or cameras? Have you ever wondered if your employer is watching you through cameras in the workplace or even tracking your location with GPS on a company vehicle or phone? It might sound unsettling, but here's the reality. Employers do have the legal ability to monitor workers in many ways, but there are important limits. Federal law, state privacy laws, and company policies all shape what's allowed. In most cases, employers can use cameras in public areas of the workplace, and they can track vehicles they own. But hidden cameras in private spaces or tracking off-the-clock movements may cross the line. In this video, we'll break it down step by step. What the law says about cameras, what the law says about GPS tracking, where workers have privacy rights, and how real cases have played out. By the end, we'll know what kind of monitoring is legal and when it's not. 1. The legal basis for workplace monitoring. Unlike some countries, the United States does not have a single, comprehensive federal law that governs workplace privacy. Instead, rules come from a mix of federal statutes, state laws, and court decisions. At the federal level, the Electronic Communications Privacy Act, ECPA, allows employers to monitor communications and activities on company-owned systems for legitimate business purposes. That includes email, internet use, and in some cases, location tracking. When it comes to cameras, courts have generally allowed employers to monitor areas where workers do not have a reasonable expectation of privacy. That means it's usually legal to put cameras in hallways, factory floors, or retail spaces. But it is not legal to place them in bathrooms, locker rooms, or other private spaces. As for GPS tracking, courts have upheld employer use of tracking devices on company-owned vehicles. The reasoning is that employers have a legitimate interest in knowing where their property is and how it's being used. 2. Cameras in the workplace. Let's look specifically at cameras. Employers often argue they use cameras for preventing theft, monitoring productivity, ensuring workplace safety, protecting customers and staff. Federal law generally permits this, but some state laws add restrictions. For example, California and New York prohibit hidden cameras in areas where workers reasonably expect privacy. Connecticut requires employers to notify employees if they use electronic monitoring. Delaware has a similar notice requirement. Example, a retail store installs visible cameras at checkout to prevent theft. This is legal, but if the store installs hidden cameras in the employee bathroom, that is illegal and could lead to lawsuits. Another issue is audio. Recording video is often allowed, but recording sound without consent may violate wiretapping laws. Some states require all-party consent for audio recording. That means cameras with microphones may create legal problems unless workers know about them. So the takeaway, cameras in open areas are usually fine. Cameras in private areas or with hidden audio are not. 3. GPS tracking of vehicles and devices. Now let's turn to GPS tracking. Employers increasingly use GPS to track delivery drivers, sales staff, and anyone using company vehicles or phones. Courts have generally upheld GPS monitoring when the vehicle is company-owned and the tracking occurs during work hours. The purpose is legitimate, like ensuring routes are followed or preventing misuse of company property. Example, a delivery company installs GPS in all vans to monitor routes. This is legal. But if the company uses the same GPS data to monitor where employees go after hours when the van is parked at home, workers may have privacy claims. Personal vehicles are different. In most states, employers cannot require GPS trackers on privately owned cars unless there is consent. Phones add another layer. If the phone is company-issued, GPS tracking during work hours is usually legal. but continuous tracking after hours may cross into invasion of privacy. 4. Real-world cases and court decisions. Real examples show how these rules play out. Case 1. O'Connor v. Ortega, 1987. The Supreme Court held that public employees have limited privacy rights at work, but employers can conduct reasonable searches for work-related purposes. Case 2. Elgin v. Coca-Cola Bottling Company, 2005. A court upheld GPS monitoring of company vehicles, ruling it was reasonable for the employer to track routes. Case 3. California Hidden Camera Case. Employers faced lawsuits for placing hidden cameras in locker rooms. Courts found this violated state privacy rights, even if the employer argued it was for security. Case 4. Phone tracking controversy. In several cases, employees challenged constant monitoring on company phones that track them after hours. Courts suggested off-duty monitoring may violate privacy rights, especially without notice. These cases teach us that courts usually support employer monitoring, but only if it is tied to business needs and not overly invasive. 5. Worker rights and protections. Even though employers have wide latitude, workers are not powerless. Notice requirements. In states like Connecticut, Delaware, and New York, employers must give notice if they monitor electronically. Reasonable expectation of privacy. Workers are protected in spaces like bathrooms, locker rooms, and sometimes even break rooms. State constitutions. Some states, like California, recognize a constitutional right to privacy that extends to private sector employees. Union contracts. Collective bargaining agreements often limit surveillance and require negotiations before cameras or GPS are introduced. Federal laws. The National Labor Relations Act, NLRA, protects workers from surveillance intended to interfere with union organizing. If an employer uses cameras to intimidate workers during organizing campaigns, that may be illegal. Example: warehouse workers notice cameras aimed directly at union bulletin boards. They file a complaint, and the NLRB rules that the surveillance was unlawful interference. 6. Best practices for workers. If we're worried about being tracked or recorded, here are smart steps. Know your state law. Check if notice is required or if additional privacy rights exist. Understand company policy. Many employers disclose surveillance in handbooks or contracts. Separate personal and work use. Don't assume company vehicles or phones are private. Challenge excessive monitoring. If cameras or GPS seem overly invasive, consult HR, a union rep, or an employment lawyer. Keep context in mind. Monitoring for safety is usually legal. Monitoring personal lives is not. Example: a worker discovers their company phone tracks them 24/7. They raise the issue, and HR adjusts the settings so GPS is only active during work hours. 7. The bigger picture technology is advancing faster than the law. Employers now have access to AI-powered cameras, biometric scanners, and detailed GPS data. For workers, this raises big questions. How much privacy do we give up when we take a job? Lawmakers are starting to respond. States like New York now require notice of monitoring. California courts continue to expand privacy rights. Congress has debated stronger workplace privacy protections, though no federal law has passed yet. Until then, the balance remains. Employers can monitor for legitimate business purposes, but workers still have rights in private spaces and against excessive surveillance. So, can employers track us with GPS or cameras? The answer is yes, within limits. They can use cameras in public areas of the workplace, but not in private spaces. They can use GPS on company vehicles and phones during work hours, but off-duty tracking may violate privacy. And in some states, employers must notify workers before monitoring at all. For workers, the key is awareness. Don't assume work vehicles, phones, or offices are private, but if monitoring crosses into personal life or violates state laws, there may be grounds to push back. If this video helped clear things up, share it with coworkers. The more we understand our rights, the better we can protect both our privacy and our jobs.